Grazie Presidente Morris, come sempre ci dà uno sguardo di quello che succede al di là dell'oceano. Io credo che forse allora quest'anno, facendo gli scongiuri, ma poi lascerò la parola al Presidente Rordorf, che è il più deputato a parlarne, magari il legislatore italiano sarà un po' più svelto del Congresso, no, nel recepire quelle che sono le riforme in cantiere. E passerei la parola a Chaterine Ottaway. Chaterine Ottaway è un avvocato francese che si occupa da tanto di ristrutturazioni, è nel Consiglio di amministrazione di Insol Europa, con cui spesso naturalmente ci vediamo, è già stata past president di Insol, e ci porterà sostanzialmente l'esperienza della legge francese sull'insolvenza, soprattutto degli ultimi modifiche legislative che sono intervenute in questo Paese, per quanto riguarda in particolare sia le procedure di allerta sia le possibili competizioni nell'acquisto delle imprese in crisi. Intanto la ringrazio anche personalmente per aver accettato il nostro invito, sapendo anche i suoi molteplici impegni professionali. Chaterine.
Grazie. Okay. Well, Cecilia Morris was great with her Italian words, so I'm not going to do that. Maybe in my mother language. Bonjour à tous. I'm a French lawyer. It's a pleasure and honor to be there, and of course I'd like to thank the organization and especially Antonio Tullio because it's a very efficient organization. You asked me to speak about some different items. The first one would be the alert procedure in French insolvency law. The second is the new possibility for creditors to propose certain condition, a competition plan to the safeguard plan. Then the new possibility in France for the courts to expulse shareholders and managers. And finally, the new specialized commercial court for big insolvency matters, which just has been created. And I will probably, if I've got some time, speak a little about Insol Europe, because that could be of an interest for all of you. So the first one is the alert procedure in French insolvency law. This is prevention. Prevention law is quite new considering the time we've had insolvency law in France. It is quite an efficient way to avoid insolvency when it's still possible. There is different steps for that and different people who can do it. The first one who can make the alert procedure is the statutory auditor of the company. He has a big role, and now the role is even more important, that his responsibility can be called if he's not doing the work, because as you may know, in France, statutory auditors are not the friends of the company, even though they're paid by the company. They are the police of the company. They have a real control on the company and the accounts. So the statutory auditor must inform the manager of the facts likely to compromise the enterprise going concern. It is an obligation which has been codified under the Commercial Code. The facts concern the financial position and the operation of the company, and it constitutes events which are objectively susceptible to affect the continuity of the company in a foreseeable future. It can be, for example, a negative equity, deterioration in working capital, negative cash position, inability to renew at maturity the necessary credit, failure of a significant debtor, removal support from the holding. All this is really very often used, and the subsidiary who has difficulties will have to ask the shareholder, the mother company, a letter saying that they will go on supporting the subsidiary, and if they don't, then it will be the start of an alert proceeding, and it's quite automatic now. It can also be negative cash flow, the loss of important client. It can be difficulty in raw material supplies, major repeated strikes, and you may know that in France this is not just a virtual possibility. It can also be major tax adjustment, which is also something which happened quite often in France. Political upheld in a country where the business is well underway. Well, there's plenty of different possibility where the auditor must start the alert proceeding. Then there will be what we call the zero phase, not the phase one, the zero one. It's an official phase, and it's a very efficient one. Before the outbreak of the alert proceeding, which is official, more or less, the first phase, there will be an interview with the auditor and the manager in which the manager will have to convince the auditor that in fact it's not a real problem and there is solution and there shouldn't be any alert procedure. It is known that a lot of professionals believe that in nearly half of the cases, this approach, which is, be careful, there's something wrong, I got a red light, you should be careful, this brings to the manager the attention to some problems that probably you will not consider as so important, but when the auditor is coming and say, I got a question, then they will try to manage and find a solution. So it will avoid the alert proceeding, and that's really practical. Then you've got the phase one, which is the between you and me letter, where it is not a meeting, it is a letter, a registered letter. It is codified by the commercial code as well. And the chairman of the board is informed of the facts likely to compromise the continuity of the business. And he has 15 days to make an answer which is satisfactory for the auditor. If there is no letter back to the answer of the auditor, or if the answer is not satisfactory, then you'll go to phase two. At the phase one procedure is confidential. It is just with the chairman. But if it's not satisfactory, then phase two is the invitation to consult the board letter. And then if the chairman doesn't answer or doesn't give the right answer, the auditor found that the situation is still the same. He will invite in writing the chairman to obtain a deliberation from the board of director or the supervisory board, and then when you receive the letter, the chairman has 8 days to convoke the board. Then they must deliberate within 15 days. So it's quite regulated. The auditor then must also be convoked to the board, and the auditor will inform the board, the existence of this board. He will inform the president of the commercial court, and he will also inform the labor committee of the company. So it is not confidential anymore. And after this, there is phase three, which is the report to the general meeting. In the absence of convocation of the board, or if the board has not found any solution, then the auditor will go on with the procedure. He will prepare a special report to be presenting to the shareholders in a general meeting. And the report of the auditor shall be addressed to the chairman of the board or the management within 15 days of the deliberation of the board, and the report will be submitted by the chairman to the Labour Committee within 15 days. So it will really be official this time. In this alert proceeding, when the court is informed, you should know that the president of the court and that the second stakeholder who can do the alert procedure is the president of the commercial court. He is informed of the alert proceeding, and he can convoke in an unofficial meeting the president of the company at the court itself in order to understand if the company is in a real difficulty or not. This is through the alert proceeding of the statutory auditors, but it can also be through the commercial register. at each commercial court in France, you've got a commercial register where you have to registrate your accounts, the deliberation of the board, and that kind of documents. If, for example, you have some creditors publishing that they're not paid at the register of the court, or if the accounts are very bad, then the president can also alert the president of the company and ask him to come and discuss about the situation of the company. When you are convoked as a president of a company, you have to go. It's much better, and you can be assisted by a lawyer. Then the third stakeholder who can do the alert proceeding is the labor committee. And you know in France as much labor law is an important fact in managing a company. It then also have an alert right. It's issued from the labor code. And he must alert the facts likely to affect alarmingly the economic situation of the company. This procedure is possible also when they want to make a consultation of the labor committee on strategic choice of the company, and the labor committee may be assisted by an accountant paid by the company itself. We have in France a labor committee when the company has more than 50 employees during at least 12 consecutive months during the last 3 years. So there's quite a lot of them. Then you also have the possibility to alert the president of the company through another proceeding where he is much more in charge, which is the mandat ad hoc, and I guess some of you have heard about it. The mandat ad hoc is a proceeding which is quite informal, in fact. It has been created in the 90s by the Commercial Court of Paris because of the problem with the real estate agent. And upon request of the president of the company, and only the president of the company, the shareholders can do it, he can ask the president of the court to appoint an administrator, mandataire ad hoc, which is with a specific mission. And the mission can be to help him to resolve some of the problems he faces, which can be a problem for the company. For example, the shareholder doesn't want to pay money to the company in order to go on, and they had made a promise for that. They have a litigation with the supplier, and they can't find any solution. They have a problem with some employees, and they can't find any solution. And therefore, the mandataire ad hoc will have a sort of mediator. He has not real power, except that he has been appointed by the commercial court, which makes him somebody with a role in the negotiation. And for example, when you have a problem with your banks, you can also do that, and most of the banks will like to be discussing through the mandat ad hoc, because it will make it more, even if it's confidential, more official concerning what they can accept as negotiation in order to postpone the payment of the debt, for example. They know that they will be under the protection of the court as well. Then the second item I wanted to speak about is the new possibility for creditors in France to propose, in certain conditions, a competition plan to safeguard plans. In France, we have various possibilities for prevention. We have the mandat ad hoc, which is really the first one. Then when you are still an in bonis company, meaning that you're not in bankruptcy situation, you can now have the safeguard, which is our French Chapter 11, which is far from the American one, of course, because it's French. But also it's a way to do a reorganization without being bankrupt. And it has more or less the same proceeding that when you're bankrupt, because all the creditors will have to declare their claims. You won't be allowed to sue the company, or if you do so, you will have delay to be paid. Then there's plenty of protection, even for the managers, if they gave their guarantee to a bank, their personal guarantee, for example, it can't be used. So the safeguard procedure has been used quite often, and at the beginning when it was created, it was in the end of the management, in the end of the president of the company, because he was the only one who could ask for a safeguard to be open to the court, and he was the only one who could present a plan to reorganize the company. So we used to say that it was a real risk for the creditors, because it was, unless the company was going bankrupt, he could reorganize the thing more or less like he wanted. Since March 2014, there was change, and now it is applicable since July 2014. In the safeguard procedure, when there is a committee, meaning that it's for big companies with more than 150 employees or more than 20 million turnover, that's the condition. When you get that committee, a creditor from one of the committee can present a competition plan to the plan presented by the management of the company. It is only the creditors committee which can submit this competitive plan. It is the threshold that I gave you has to be respected. We have two kinds of committee, the one for the credit institution and the one from the main suppliers, and which means that, for example, the general meeting of the bondholders cannot present a competition plan. Some creditors cannot present the competitor plan, just like the, for example, the tax or social creditors. I told you about the bondholders, and these competition plans, if they're accepted, if they are voted, can take the power out of the company as it was at the beginning. The draft plan has to be communicated to the administrator by a registered letter, no later than 15 days before the date of the first vote concerning the plan to be presented. The plan proposed committees are not subject, maybe making more simple. The project may provide the payment terms, the discount, and the debt security, the conversion of the debt, if there is any. Each project may establish differential treatment among creditors if the different situations justify it. They must take into account the subordination agreement between creditors concluded before the opening of the procedure, which is very new, because maybe you know that, but in France, when you are an unsecured creditor, there is no rank between you. When you're an unsecured creditor, you are full stop, no rank between the people. So if they made any subordination agreement, and if you have senior or junior but unsecured, same position. So in this kind of plans in the safeguard, the subordination agreement between creditors are taken into account. The shareholders' debtor of the company retains still a veto because they still have their vote, and so there can be a problem. That's why it came to the third point, because I'm coming to the shareholders, really. The shareholders who has a veto for the plans. The legislation made a very big quote unquote evolution since the new Macron bill. Yeah, I'm sure you know Mr. Macron, who is a very dynamic minister in France, young and non-socialist. and he passed the Macron bill in February 2015. The Congress did not vote it because he's a speedy man. He just used an article from the Constitution, 49.3, saying that in special occasion, the government can pass a law without the Congress. So it's a speedy one. The law was passed, but a lot of decree of application are not yet written. So it takes a little time anyway. But it introduces for the first time the power for removal shareholders when there is a judicial reorganization plan under consideration. In March 2014, there was a hot topic about that because the first article was introduced in the Commercial Code concerning the possibility for management and shareholders to be expulsed. That was when, and that was the condition, when they refused to reconstitute the capital stock of the company. So it was not a real big challenge at the time in 2014. But with the new article from February 2015, this condition is not indicated. The new condition is that it must be a company with more than 115 employees or dominant. It is only in a bankruptcy reorganization process, so it's not in a safeguard or in conciliation. It must be justified because otherwise it is likely to cause serious disturbance of the national or regional economy and employment area. So that's another condition. So at the end of the day, of course, it is not a very frequent occasion, but I think it's going to be more frequent in the next few years. You must know that as we are touching here to the sacred right of property, constitutional right of property in France of the shareholders, this provision of the new law was brought to the Constitutional Council, and on the 5th of August this year, they decided that there was no problem, no disproportion with their right, because it's under these very strict conditions. So if they refuse to vote, if their shareholders refuse to vote the plan, then the administrator can appoint an agent who will vote instead of the shareholders. The creditors may use this system without bringing any new money. If they bring this new plan, they can say, I'm going to set up my claims and increase the capital. And through this mechanism, and if the shareholders refuse it, take the power into the company. This is really, really new in France. Of course, it will not for all companies, but there will, I think, a lot of problems because, for example, if they are expulsed, you have to buy their shares. What price? The law says an expert will be appointed, but we don't know how he will be appointed. We don't know at which value he will buy the shares. It can be the liquidation value, the going concern value. We don't know what will happen if the plant is in breach later on. And we don't know what happens if there is a success. Will they be able to, for example, to ask for an earn-out because they were kicked off at a liquidation value? We don't know. So I think it's going to be interesting to see in which company this has been done. As I have not a lot of time, just quoting the fact that we have also created, since August the 7th, 2015, we have commercial court in France. You know, it's lay judges, elected judges for 6 years. It has been like this since before the French Revolution, so 400 years more than 400 years. So it's not. It's a very old institution, and they decided for big bankruptcies, and for bankruptcies dealing with the European rule for cross-border liquidation and bankruptcies, to be chosen among the existing courts. Maybe it will be Paris, Lyon, Marseille, that kind of town where there will be big proceedings. And these specialized courts will have people really specialized in bankruptcy law, much more than just now. For the really big bankruptcies, they will be able to appoint, with the new rules coming up in 17, to appoint the administrators, because there will be 2 of them, so they will be allowed to do so. So this is an organization preparing the rules for the cross-border within 1.5 years. And just a last word, because I'm sure Antonio would do it as well, about Insol Europe. Insol Europe is a French association. I'm sorry, it's French. It's a French association with practitioner of insolvency. It can be bankers, it can be lawyers, administrators, judges. We are more than 1,250 members across Europe. It's all individual. We have a review, Europhoenix, a website which is very useful, I think, to people practicing bankruptcy. We have Congress every year, a Congress in the Eastern country as well. All members, for example, we are, I told you, 1,200 members, and we have more or less 450 to 500 members coming to our Congress every year. So everybody is really concerned by the association and the work of the association. And if you're interested, I'm sure Antonio Tullio will give you all the information about our association. Thank you.